In this video, what we're going to be doing is talking about the different types of delegated legislation as part of the broader lawmaking authority that we see in the English legal system. Specifically then, we will talk about the different types of delegated legislation, sometimes referred to as secondary or subsidiary legislation. Now, in terms of what delegated legislation actually is, it is essentially a form of law that is made by an individual or an administrative body under the powers that are given to them by a piece of primary legislation, namely an Act of Parliament. Parliament ultimately cannot address every single specific detail of governance across the entirety of the United Kingdom, so it has the authority to delegate to other bodies and officials to make rules, regulations, and orders necessary to enforce or to fill in the gaps that are associated with the primary legislation. The types of delegated legislation we're going to talk about in this lesson are statutory instruments, orders in council, bylaws, regulations, and orders and resolutions. And we'll also finish by thinking about some of the basic features of delegated legislation before examining some other aspects of delegated legislation in the next lesson, specifically the ways in which Parliament and other institutions controls delegated legislation. So the first point that I want to mention is this in relation to statutory instruments. Now, a basic definition is as follows. A statutory instrument is a common and widely used form of delegated legislation. It is made by the government ministers under the authority of a parent Act of Parliament. Statutory instruments are used to bring into effect the provisions of a piece of primary legislation, to set the specific details of a piece of primary legislation, or to modify the existing law in response to changing circumstances. However, I should just make it very clear that the modification of the existing law is done in accordance with and under the remit of the primary legislation still, so it is done with that legislation's permission nevertheless. The aim here is to essentially provide the technical details or the administrative measures which are required to implement the objectives of a broader Act of Parliament. So, for example, the Environmental Protection Control of Pollution Amendment Regulations of 2018, as well as the Consumer Protection Regulations of 2000, are both examples of regulations that further help to implement and to act under the authority of a parent piece of legislation. Statutory instruments can be made either through an affirmative procedure, which is essentially done by the approval of both Houses of Parliament, the House of Commons and the House of Lords, or through something known as a negative procedure. This is when it automatically becomes law unless it is rejected by either house. So it's a negative procedure because it is automatically the case and it has to be rejected in order for it to not be operational. An affirmative procedure obviously requires the positive act, which is the approval of both Houses of Parliament. Of these two procedures, the majority of statutory instruments are made under the negative procedure system. An order in council is a form of delegated legislation that is made by the Crown, or at least made under the auspices of the royal prerogative, usually on advice of government ministers. These are typically issued under powers granted by primary legislation and are used for a variety of purposes, specifically in relation to, for example, changing laws in territories outside of the United Kingdom, or even when it comes to making emergency regulations. So the purpose of orders in council is that they can be used to make broad changes to the law or to deal with matters that affect the UK as a whole, such as administrative changes or just the exercising of royal prerogative power. Now, the Privy Council can make orders in council to alter the boundaries of the United Kingdom, to change laws governing the territories, like in places such as Bermuda and Gibraltar, or even to make amendments to under specific pieces of legislation. One such example of this is the use of the Privy Council under the auspices of the Emergency Powers Act. Orders in council do not typically require approval from Parliament, but can still nevertheless be annulled by Parliament within a specified period if it is challenged. The process, however, is less scrutinised compared to that of statutory instruments. Bylaws are made by local authorities or public bodies, such as local councils, universities, or public corporations. This is within their areas of jurisdiction for specific functions. They derive from the powers that are given to local authorities, though, under a piece of legislation, i.e. an Act of Parliament. Their purpose are essentially to regulate specific matters within a locality or a particular institution, such as public behaviour, safety, and the regulation of social services. They often deal with issues like control of traffic, public conduct, or even the licensing in particular areas. So, two examples that we can see here is, for example, a local council may pass a bylaw which regulates the hours in which street trading is permitted, or a university may pass a bylaw governing student conduct and discipline. Both examples of how they work. Now, generally speaking, bylaws are usually subject to a system of local consultation and can be challenged in court if they are found to be seen to be acting beyond the authority of the enabling statute. That is to say that they are acting ultra vires. Some bylaws may also be subject to approval by a government minister or a specific body, such as that of the Home Secretary. Regulations, then, are a form of delegated legislation that are typically used for the implementation of an Act of Parliament, and so they are usually more detailed than that of specific statutory instruments, and they often deal with the technical or the procedural aspects of a particular piece of legislation. They provide a framework for which the main law, the Act of Parliament itself, is able to operate, and they often involve administrative tasks, setting standards, or establishing procedures to ensure compliance with the primary legislation. And the two examples that I've got here cited are the Food Safety Regulations of 2013, General Food Hygiene Regulations, as well as the Health and Safety First Aid Regulations that were established in 1981. Regulations can be made by government ministers or even regulatory bodies with powers granted by primary legislation. Just like with statutory instruments as well, regulations can be made either through an affirmative process or a negative procedure. The regulations often focus more on administrative details. So with all of this being said then, there are a number of key features that are associated with delegated legislation that makes it unique to that of parliamentary statutes. Firstly, delegated legislation is made under the authority of an enabling act of Parliament. This is a primary legislation or a parent legislation that is used to specify the extent of the powers and the procedure in place that is necessary for making such legislation. The Parent Act lays down the framework, and the secondary legislation essentially fills in the details. It has the ability of being flexible and detailed. One of the primary reasons for utilising delegated legislation is its ability to provide flexibility, something that Parliament often does not have time or even the expertise to deal with, especially when we're talking about the detailed aspects of every single piece of legislation. Delegated legislation, therefore, enables quicker and more effective regulation, especially on issues of technical, administrative, and rapidly changing matters. They are also able to be scrutinised and to be held accountable to Parliament. While Parliament grants the power to make delegated legislation through primary legislation, there is often a system of parliamentary or judicial scrutiny that places controls over those pieces of legislation. We will talk about the controls of delegated legislation in the next lesson. But generally speaking, statutory instruments, for example, have to be subject to the negative or affirmative procedures that we mentioned, meaning that they either automatically are adopted unless rejected, or must be explicitly approved by Parliament. Additionally, some forms of delegated legislation, such as bylaws, may be subjected to judicial review to ensure that they stay within the basic powers that are granted by the Enabling Act. And then finally, there are some limitations on its flexibility and its efficiency. So, for example, subdelegation, which is the power to make delegated legislation, the power to make delegated legislation cannot go further, cannot be further delegated unless expressly authorized by the enabling statute. So, the authorities that make or that implement the delegated legislation have to refer back to the primary enabling legislation in order to go through the process known as subdelegation. You also, of course, have the ultra vires doctrine. Delegated legislation must comply with the powers and limitations that are set out in the enabling statute. If they exceed these powers, then they are declared to be ultra vires. And finally, parliamentary scrutiny. We'll talk about this in more detail in the next lesson, as I've just mentioned, but while Parliament does not pass every piece of delegated legislation, it still nevertheless remains and maintains oversight through procedures such as the Joint Committee on Statutory Instruments, or through the affirmative and negative procedures in place to actually pass those pieces of legislation in the first place.